Now this panel is called Donor Intervention. And I became keenly aware of the strength, the real strength of the international financial institutions relative to the rhetorical and not real strength of what is normally thought of as the strongest of all international institutions, the Security Council, in my work on accountability in the former Yugoslavia. And that's because they have all these war criminals in possession of countries like Croatia and Serbia, who they were refusing to turn over to the International Criminal Tribunal created by the Security Council. And the Security Council would pass countless resolutions condemning their non-compliance and urging them to comply, and nothing was happening. This is the strongest body in the world. And then the IMF comes around and says, we're going to withhold your IMF loans unless you surrender your indicted war criminals. And within 5 minutes, they all came marching. And then with regard to Slobodan Milosevic, it turned out that the international community, by giving an aid package of $1.6 billion contingent on Serbia surrendering its former leader, that had much more strength and much more to do with the fact that he finally faced justice than all the kinds of threats and sanctions put together. So they say follow the money. They say ultimately money is what matters. In the international community, it does in many different respects. So today we're going to be looking at that issue in terms of nation building from the perspective of two experts in the field. Their bios that are very lengthy and most impressive are in the book, and I suggest that you read through them. But rather than take too much time on it, let me just say that Sean Hagan, our first speaker, is a longtime friend of both Hiram Chodosh and the law school, where he has come before for other speeches. And I met him the last time he was here when he, as deputy counsel of the IMF from 2003 to 2005, was handling IMF relations related to Iraq and other things related to the subject of our conference. Well, it's nice when our friends rise up to high places, because Sean has just this year been made the general counsel of the IMF, and we're very happy to have you here, Sean. And following Sean's remarks, we have Linn Hammergren, who I just met for the first time, but I've known of her work and read her writings before. She's a former professor from Vanderbilt who spent many years in the field as part of USAID, and she's now a senior policy specialist in judicial reform at the World Bank. So we have the IMF and World Bank experts today to talk about the role of the international financial institutions in nation building in Iraq and elsewhere. Sean, do you want to begin?
Thank you, Michael. And first of all, let me apologize to all of you and to the law school for having to ask you to turn off.
I'm going to be talking about the Latin American experience with rule of law reforms, and I'm really going to be talking about it from the standpoint of, I suppose it is from a donor standpoint, but most of my experience actually was with USAID. And the two examples that I will use, if I ever get that far during my 25 minutes, are countries where I worked with AID and not with the World Bank. Since I often don't get as far as I want in these presentations, I'm going to start with the conclusions and then hope that I can reach them again by the end of my time. Why talk about experience in Latin America to a group who's clearly interested in other regions, and why talk about experience in Latin America when the problem there was really not nation building? As I'll talk about, there's a certain element of state building or state rebuilding. I think one of the reasons is that, and I guess the reason I was asked, is that this was really this has been the longest experience of combined national and international work on rule of law reform in any region recently, and it became the model for work in a lot of other countries, including some of the ones that are more interest to this group here. And it is a model that I think has to be better understood so as to avoid making some of the same mistakes that we made and are continuing to make. And out of this come the 4 points, and the first of these is that you can't resolve all socioeconomic problems with a rule of law or justice reform. We have overpromised. Overpromising has served us well. I love it that the economists never question why we're doing this, because our mantra is it takes a well-functioning justice system to create a market economy, but I don't think the jury's in on that one. So, and I'm not sure that if you create the well-functioning justice system, assuming you can, that the market economy follows. There are other reasons for wanting to create a well-functioning justice system, but we need to be more modest about our justifications. Second, and this is one Hiram won't like, but I will amend it immediately with the third one. What you can do to change a justice system, what you can do in the way of rule of law reform, is necessarily limited. It takes time, it takes resources, and it takes the ability to overcome some, or to build some deeply entrenched behaviors and attitudes. Now, it takes time has been criticized as sort of an obvious and not very clarifying remark, but I will say after that although what you can do is limited, it is well to start out with some concrete objectives and to be precise about what the reform, and this is whether it's a reform donors are promoting or a country is promoting, is going to achieve. It doesn't do any good to rest on that. It takes time, and say, as the representative of another U.S. government agency once said to me, well, just give us the money and come back in 10 years and we'll see what we've done. One needs to be a bit more precise than that. And finally, and this is something that isn't in the paper but has been increasingly occurring to me, I've devoted a lot of time, nearly 20 years, to working on rule of law reforms in Latin America, but it occurs to me that I always seem to be working out here in left field while the other development work is going on somewhere else. And I think the work that we have done in rule of law has paid a price for it, and I think some of the things that we're working on are beginning to come into conflict with other kinds of development objectives. So I think the integration of these programs is important. Rule of law tends to be regarded by others as esoteric, and I think we like to regard it as esoteric. No one bothers us, but I think that has been a counterproductive way to act, and I think it's important to change that. Okay, what I'm going to do from here on in, and see how far I'll get, is tell you a little bit about what this 20 years experience in Latin America was about. I would like to get to the two examples that I think come closest to nation and state building. One, a relative success, which is El Salvador, and one, a widely regarded failure, which was Haiti during the 90s, and talk a little bit about what those may have of more specific interest for people like you who are interested in countries that didn't have some of the advantages the Latin American countries had. This is a movement that began in the 1980s in Latin America, and it's a region-wide, although focused in individual nations, reform movement that has continued to this day. One of the reasons that has been sustained so long and became so important was certainly the participation of foreign donors, and here not just the international financial institutions. In fact, the first donors in tended to be bilateral donors and working in grants and not in loans. And there were also a variety of civil society, advocacy, and special interest organizations from outside the region that got involved. Groups like your own, law schools, the international arms of the American Bar Association, a number, particularly U.S. agencies, but increasingly now from other developed countries, which are non-governmental but which get involved in this kind of program. Over these 20 years, the combined efforts of all of these actors, and I want to stress the national governments as well, have substantially changed the shape and the political weight of the justice sector in Latin America. And by the justice sector, I don't mean just the courts. I mean bar associations, prosecutors, defense, even police, other agencies that are involved in rule of law. They've altered the legal framework, and they brought sector operations more to public attention. And one of the things that strikes me in the time that I've been working in Latin America is the fact that I can pick up any newspaper in any country, and there's some article on what the courts or the police or the prosecutors are doing, and that certainly was not the case when I started. So this is much more under discussion. There is, however, a growing concern as to whether this is actually improved performance. And there have been a number of public collections of public opinion surveys done recently which tend to suggest that approval for, it's often in terms of the courts, but they're really, the public sometimes confuses this with other institutions. So just for the sector operations tends to be very low and has even dropped off in the last few years. Only a few countries, Chile, Costa Rica, and Uruguay, and those were always the ones with high scores, score as high as 40% approval rates. And many of the region's countries are down near 10, 12, something percent. I think that well, we can question a little bit whether public opinion polls might be influenced by other things. And I think that although I'm skeptical about whether we have reached some of the goals that we said we would, I think it's clear that there have certainly been some improvements. But the real questions are whether the resources that were invested could have been used to accomplish more, whether more could have been accomplished with these resources, and whether what remains to be done could be done now, whether we've done enough so that these other things are likely to occur, particularly as the donor agencies and the outsiders begin to move out of this area. As I said, most of this didn't occur in a state or nation-building situation, that is to say a situation where a society had collapsed or where people were questioning belonging to a nation or where there was very little state left. It really came about, and I think this was an advantage for the region, as the result of a nearly region-wide emergence from a period of repressive governments under military or civil military dictatorships. And very few countries in the region were accepted from this experience during the 60s and 70s. The transition was accompanied by a good deal of violence, including civil war, particularly in Central America, militant resistance movements in the southern cone in Brazil, and other kinds of resistance. But once the military left, you didn't really have collapsed societies or states, and in fact there was sort of an environment of hope that now we're going to do something. We're going to do something different. This was a period when during the early 80s, when many of the countries rewrote their constitutions, and they rewrote them specifically to reverse some of the tendencies associated with the prior governments, including changing the balance of powers to reverse the tradition of presidential centralism, recognizing more political and civil rights, and dedicating state efforts to the resolution of social problems. Some of these constitutions are so promising of what governments are going to do that they in themselves have become problematic, and particularly in the area of rule of law, because guarantees that are made, courts are now being asked to enforce, and there's a question of whether the government is capable of doing it. But in any case, this was part of this whole atmosphere of we're going to do things differently now. That accompanied this transition, and more specifically related to the rule of law movement. Then, the status of the courts during this period, during decades before, as what was called the Cinderella or the orphan branch of government, was seen as part of the problem. And in many countries, the judiciary, the police, where it existed prosecution, had been used by governments to repress opposition. And so part of this constitution writing and change the legal framework had to do with giving a different status to the sector. And you find then that the court's roles in ruling on the constitutionality of laws and government actions was enhanced. There was an increase in the mechanisms that citizens could use to access their rights, and there were real efforts to enhance judicial independence, particularly through things like guaranteed budgets, new appointment systems, guaranteed tenure in office and career systems for judges and prosecutors where they existed, and a prohibition on reducing judicial salaries. So this was, and judicial governance was entrusted to either to the Supreme Courts or to a new group of judicial councils. I should note here that in Latin America, the sort of civil law European tradition of having ministries of justice run the courts had really not been the rule even before. There was a lot of intervention from the executive, but even while the Supreme Court was often the official, not just the highest level court, but also was the body that was responsible for judicial governance. Two other things that came out of, or another thing that came out of this period and was locally inspired, was a drive toward reforming criminal justice systems. And this is where most of these reforms got started in the 80s. A move toward more accusatory criminal justice systems on the assumption, which I think needs to be tested, that they were fairer, more transparent, and eventually that they would even be more effective in combating crime. But this was something that was believed by groups in Latin America. It wasn't a wide demand because rather small groups of jurors who promoted this, but this was what these countries saw as important, and so this was what became part of this movement. As the donors got involved, and it's interesting that the donors in the beginning didn't want to change laws because there'd been an earlier movement in the 60s and 70s where part of the assumed failure was supposed to be due to getting involved in changing laws. So the movement toward legal change really came from the Latin American countries and from concerned groups within them. Usually, I should say, not the courts, but legal scholars, NGOs, the sort of eminent jurists of the countries. The courts often got dragged along on these reforms, but in the end, they decided they benefited them. As the donors got involved, they added some other elements. And these included things like an emphasis on efficiency, on court administration, on delay reduction, and on automation, on judicial training, and eventually alternative dispute resolution, legal aid, and civil society participation. So these were themes that the donors brought in and joined to these sort of indigenous demands for a vision of what judicial reform was about. In the beginning, some of these donor additions, and particularly things like alternative dispute resolution and automation, were very much resisted by the state institutions, the courts, police, prosecutors, but they've come to embrace them. And I find that in some cases, Latin American judges are more wildly enthusiastic about ADR than I find with judges in the States. So they've become true believers, and automation as well. You find courts saying we can't do anything until we get the computers. Over the 20 years or so then that this movement took, there have been substantial changes, and I wasn't going to list these, but since I may be speaking to an audience who wants something a little bit more concrete, just let me list very briefly what the kinds of things happened. Higher budgets and salaries, especially for the judiciaries, but also for other sector organizations. Latin American courts are, in terms of percent of government budgets, among some of the highest financed in the world. And their judicial salaries aren't bad either, although they still think they're not earning enough. An expansion in organizations' national coverage and changes in their internal structure. Changes in the legal framework aimed at bringing procedural and substantive laws into compliance with modern needs and values. Strengthening of organizational administrative structure. Expansion of information made available to the public, both on their own cases and also on the organization's operations in general. Creation of new organizations, countries which never had public prosecutors, which never had public defense, which never had human rights ombudsmen or anti-corruption offices or constitutional courts and chambers began to get them. So the whole sector looks different. Provision of alternative services, and particularly those aimed at expanding access to the poor. More attention in general to court performance. I should also say here, I don't see it in my list, just more judges and more prosecutors. Just to give you an example, as recently as 1995, Paraguay had 150 judges. It now has 570, bringing it up to 10 judges per 100,000 population, which is a pretty good ratio. And the population itself hasn't expanded that much in that time, so the number of judges per 100,000 is several times what it was before. So in any sense, I mean, there has been a lot of structural, organizational, and even changes in what happens within these organizations. But the real question is, but why are people still so negative about their courts in that region? And why haven't some of the things that were supposed to come out of this not happened? And I want to suggest here, and this may be as far as I get for the rest of this, that there are two sets of explanations. One of them are the normal set of explanations that affect any reform program, and I'll just go over these very briefly. One of these was, this could be said about financial management reform, it could be said about health sector reform, and it certainly was something that happened in the justice sector reform. One of them was just inadequate coordination particularly among the donor groups, but also within the national governments. You end up with a lot of actors and an expanding number of actors getting involved in these, and not necessarily in agreement on what they're going to do. Competition among donors is sometimes can be destructive, but sometimes it's just the fact that no one knows what the others are doing. And I would say here, too, that as more and more actors get involved, there tends to be, and this is a peculiarity for this sector, a tendency not to be familiar with what's gone before. I mean, we've now got 20 years of history with this movement, but I constantly find people getting involved in Latin America who are not aware of what was done last year or 10 years before. And so you find suggestions coming up that, gee, that didn't work before. I wonder why they want to try it now. Well, they didn't know that it didn't work before. There's been a very steep learning curve on this for everyone. The courts and other institutions in the sector had never thought about development programs, strategic management or anything like that, but the donor organizations also had never worked in this sector before. And so over 20 years they had to learn how to do it. And their vision of what needed to be done has changed considerably, although sometimes I think not sufficiently, over that period. There also were frequent changes of leadership, both among the outside collaborators and also within the sectors. When I worked in Peru during the late 1980s, during a period of about 3 years, I think I worked with three chief justices, 3 attorney generals, and 4 ministers of justice, who were all the counterparts. And so every time one of them comes in, there's a tendency for them to want to, at least they have to learn the thing all over again, but they may want to change the direction. But changes within the donor community also of leadership and also of just of interest. This year it's criminal law, now we ought to be working on commercial law, or this year it's Salvador, next year it's Haiti, and the year after it's Iraq. And funds get shifted around, people get shifted around. If you're suddenly going to prioritize a project in some country, you probably send your best people there out of wherever they were working before. And finally, there's been a tendency, there was actually not a lot of resistance, or the resistance was not very effective to these programs in the beginning, and I've often written about stealth reforms. There were some amazing changes that were made, expansion of courts, constitutional review powers, which no one seemed to object. But over time, those whose interests were being affected by these reforms have become wiser about them. But sometimes it's better to work resistance by undermining the reform from within. And here I think some of the points that were made this morning in talking about federalism, it's really not the question of whether you get a new criminal procedures code or a new bankruptcy law or something like that. It's a question of what the details are like and how groups are able perhaps to transfer the same vices as always back into the new structure. Now, I guess as far as I'm going to get on the rest of this is just talking about some of the things that are peculiar to the rule of law reforms that may have affected their efficacy. One of these, and I think here this was the nice transition from Sean, has been a tendency to rely on structural technological fixes and overlook the political and political will elements. These reforms are often uncharitably called by critics equipment dumps because there's been a lot of reliance on automation. Bring in the computers and things will change. And I think that the development banks have maybe been worse on this than others because since we work in big loans, we can finance a lot of equipment and buildings. When I used to work for AID, we weren't able to finance a lot of equipment and buildings, so we had to do other things like technical assistance, which is cheaper. But it's not just equipment. This is a kind of philosophy that goes with everything, and I take Sean's comment on the law, which was one I was going to make as well. It has to do with the impact of reorganization, of legal change, of training. Many of these things are added as though simply we put in the school and it's going to change. We change the law and people will change. We talk about this as capacity building, and we may indeed be building some kind of capacity, but people, if they're going to use that capacity, have to want to use it. And that's been the missing element. An assumption on the part of the reformers, sometimes an assumption that this would be enough, and sometimes just an unwillingness to deliver the bad news with the good news. We're going to deliver 5,000 computer workstations, but yes, you're going to have to work differently. We just talk about the workstations, hoping that will make things change. On the side of the governments, there's beginning to be a certain amount of disillusionment, particularly for ministries of finance, because they're really paying more for their justice at the moment. And there's some question as to whether money was the missing element either. That wasn't going to be another one of these quick fixes. If we just raise the judicial budget and raise the salaries, things will get better. It often didn't. Another set of problems have been, and here we get into sort of what I call the postgraduate course in judicial reform. The first one, and I guess the warning to people working in state-building situations, is don't think that the building blocks are enough. They're all you've got to work with, but you've got to use them creatively. The second one, though, has to do with the tendency to see performance improvement as a question doing more of the same better. And this is one of the things we're beginning to see in Latin America. With all this emphasis on efficiency, no one, either the donors or the national governments, really said, well, efficiency of what? And we find many courts in Latin America who have adopted all of these building blocks, indeed doing more, but having to run faster in order to just keep in the same place. And there now becomes a need to look at what it is, really the caseload, what it is the courts are deciding, and what the sources of delay or inefficiency really are. Here we get into areas like codes which allow abusive litigation, including by the government, a tendency that we've seen in many countries for the government to pass things on to the court, either difficult political decisions or, 2 minutes more, either difficult political decisions or routine administrative stuff in order to either keep from having to take the decision itself or increasingly in order to have to keep from making payment to legitimate claimants. In Brazil, this is called the government using the judiciary as a way of controlling the cash flow. And large firms also do it as well. So there's a lot of abusive litigation this way. The courts take the cases on and eventually decide them in favor of the plaintiff, but it gives it gives the defendant, the government or the large business, or just the individual debtor, several years more to use that money before they have to pay it. And a final word, and I guess I will never get to Salvador and Haiti, is that a final error has been, and this was one of the things I said in the beginning, has been the tendency to overpromise and to confuse institutional reform with a kind of advocacy or using of the courts for revolution. There are a lot of people who I think see the new role of the courts as being a way of really changing society by judicial fiat. And there's been this has been the faith on the part of the social reformers and part of the economic reformers. There's been this sense that somehow if we get the courts making decisions faster and with more computers, that people are going to invest. Or if we modernize their laws, it will attract investors, either domestic ones or foreign ones. As a friend of mine has said, and I will end with this, in regard to the economic connection or the economic impact of courts, there really is no proven connection between judicial reform and improved economic performance. But there certainly are things that we can see where specific courts are creating obstacles to economic growth. Now, it sounds like a contradiction, but what he's really saying is anything you call judicial reform will not necessarily help. Focus on the problems and focus your reform program there, rather than just assuming that capacity building is going to fix it. And I think that's probably true of the societal impacts as well. And I'll take Haiti and El Salvador in the questions.
Okay. All right, that gives us about 18 minutes for question and answer before we adjourn to get our box lunches. And I think we have a lot of food for thought here. We were going to block out this part of Sean Hagan's Q&A as well, but I'm not sure how well that'll work because both of their questions are going to be interrelated and they might want to bounce off of each other. So Sean is going to let us see how this goes and be careful what he says, I'm sure. Questions then from the audience, and we have our microphone standing by. You want to start there?
This is a question for Mr. Hagan, and it's a two-part question. One is, you mentioned on the odious debt, that there was case law from 4 countries that have held that the odious debt doctrine really is not applicable. And the first part of the question is, what is that case law? The second part is, what is the status of the Iraqi debt right now? It's not considered odious debt. I know that former Secretary of State Baker was negotiating this and seemed to have made considerable progress, but we haven't heard much from him or about his activities in the last few months.
Okay. In terms of the case law, I didn't bring all my materials with me, but the one tribunal that I do know, which had jurisdiction over the Iranian one, was the Iranian Claims Tribunal in The Hague, and basically this was an attempt by the new government following revolution to basically disavow debt incurred under the Shah. And essentially, there was an extensive opinion given by the tribunal on that case, citing some of the earlier cases, including the former Soviet Union one. And I just don't remember in what tribunal that one was, basically arguing that as a result of state continuity, the odious debt doctrine would not be applicable in that case. The case that is relatively well known, which provides a basis for the doctrine of odious debt that you may be familiar with, is the Cuba case. But that was a case of state succession, where certain debt was basically considered to be odious in the context of Cuba's independence from Spain. That was late in 1899, I think that case was. But that's the only case I'm aware of that supports the doctrine of odious debt. But I will, if you'd like, get the cites for the other 3 cases. In terms of Iraq and Mr. Baker, I think that the international community, including the United States, has firmly embraced the notion that the basis for the reduction of debt of Iraq is based on one of capacity to repay rather than on the one of odious debt. And that is the basis upon which the Paris Club has engaged in the restructuring process. Thank you. They have not reached a decision. Well, they've agreed, as far as I'm aware of, the Paris Club has reached an agreed minute, and now they're going through the bilateral negotiations to implement that.
Okay, next question is down here, please. It's just coming around to your right.
This is one for Linn Hammergren. I have a question about the 40% approval rating that you mentioned by certain donors, whoever do the evaluating. 40% seems rather low for countries that have, for the countries that you mentioned.
Yeah.
What does it take to get up to snuff?
Well, I guess I'd have to say that looking at the same sources, much of Western Europe and the United States don't do very well either. These are asking people whether they believe their courts are fair, whether they believe they're doing a good enough job, sort of thing. And the figures, as I remember, this is a Spaniard who's done some of this, for Western Europe, France, United States, Great Britain, were about in that area as well. But for the other countries, it's much, much lower. I think this is part of just what has happened recently with a sort of worldwide loss of faith in institutions. It amazed me when I saw the figures on the United States, because I thought that they would be higher for here, but they were not. But in any case, between Chile, Colombia, and Uruguay and the rest of the pack, there's a big gap. And the others we're talking about 10, 5, 20%. So maybe if you get up to 40, it's good enough. I don't know.
Okay, next question. Shibley, did you have can you bring the microphone down? Thank you, Rachel.
Thank you. From my experience in reforming the judiciary in the Middle East, I can only concur with with Linn Hammergren on a serious question of whether reform can start with the judiciary. I have come to the conclusion, I don't know if she would support it in this shape, that political change, serious change, has to come mostly in the political arena and more specifically on the leadership, the executive, constitutional leadership in the countries, not from the bottom up through the judiciary. I have two queries for Mr. Hagan, because I think that what he depicted is a very serious problem of international law and the future of international law, not so much with the relationship of the IMF and other international institutions, including the UN, with countries that are past a well-established democratic stage, but those countries that are the problem in the world, which are not democratic. And the bind here is, on the one hand, the issue you've raised about odious debts. I mean, I've worked on Iraq so much, and it's just bewildering morally to see how the people in these countries are being taxed for a pattern of engaging in debt connected with brutality that they are being made responsible for, even though those governments are now in the past. I mean, there is a very significant problem of international law in state succession law that is not being addressed, in my view, seriously enough by the major powers that you represent, including the UN. And a concomitant dimension is the fact that by convenience, perhaps even by laziness, perhaps by lack of security, the money that all these donors are giving are almost exclusively concentrating on those components of society that are particularly dictatorial, and that's the governments and those who are benefiting from the government, and that there is not enough engagement of civil society by your institutions in ways that can promote the end of corruption, the bypassing of dictatorial regimes. I understand it's difficult legally, but unless people like you who can change that think ahead of these problems, especially for transition countries, we will remain lumbered by an old mold of dealing with our societies that is not helpful.
You've raised a very important issue, and I understand the concerns regarding the very real situation of financing being extended in circumstances where the proceeds are really not used for raising the living standards of the country. I guess my point was, what is the best way to address that issue? Is it to basically call that debt odious, or to stop the financing in the first place, or to make sure that the financing is better targeted in the first place? Because by calling it odious debt, you will end up, perhaps inadvertently, by cutting off financing to other countries where, just because of the uncertainty in the market as to whether or not essentially a successor government will actually disavow that debt, which raises the question is which institution is going to make the determination as to whether or not the debt was odious under international law? Would we have to create a new institution to do that? Would it be the fund? Would it be the bank? They're a creditor. Perhaps they have a conflict of interest. It's a complicated issue. So perhaps the point is basically be more careful about the financing in the first place. And on that issue, yes, I understand the problem of what we call the democratic deficit in these issues. It's difficult for institutions like the fund and the bank, however, because our membership created these institutions specifically to be non-political. We're actually precluded from basically interfering in the social and political affairs of our membership. Now, if the international community wants to change that, they can change our charters. But until they do so, we are precluded from engaging in that. Now, there are international organizations that actually have promotion of democracy as a purpose of their activities. For example, the European Bank in London basically has the promotion of democracy. But our institutions do not, unless the bank has changed its articles recently. So that's one of the constraints that we have. Thank you.
We have a,
If I can, no, just on your question, I guess among all of the judiciaries I know in Latin America, I can only think of one that actually did its own reform, and even it is being questioned. So I think there is a problem in terms of where the pressure comes from. We have been accused of promoting guild reforms that only benefit the judges and the lawyers, but not anyone else in the country. And there are questions as to how working with judiciaries, you can get them to focus on some of the more embarrassing questions like corruption, complacency, insufficient production, bias, and so on. One thing we might do, and here it falls nicely into our Articles Agreement, is work more closely with ministries of finance. I've always been very skeptical about working with the executive to reform the judiciary, perhaps a little judicious pressure from outside in terms of show us what we're going to get for the loan might be a help. Let the judiciary design its reform, but put the objectives from someone else. If we could get civil society, if we could get the business community, it's just very difficult. It's not, one of the problems of these reforms is there isn't a really large constituency.
we also are getting questions from upstairs, and this one is, I don't know if it's from a student or a practitioner, but it says, in places like Rwanda and Iraq, does the effort to get funding for international tribunals divert international donations from the more important and longer-term effort of rebuilding domestic judicial systems? Linn, do you want to try to tackle that?
Well, that was what the part of the paper I never got to.
There you go.
It was a planted question.
I am concerned about it because I think that and this comes out of neither my work with the bank nor AID, but just knowing what other people are doing in countries like Rwanda. There really is a conflict between putting in place a dispute resolution or conflict resolution system that is going to prevent present conflicts from escalating into larger ones, and setting up a tribunal to judge those of the past. And I think that there has been a certain disproportionality in terms of where the money goes. And I also was disturbed once upon a time in Cambodia when talking to someone who was talking about the Cambodian tribunal, and I said, well, I'm not even sure the Cambodian people, this was 10 years ago, whether there's a big demand for it from the Cambodians in terms of what they feel their country needs. And he said, well, it's not for the Cambodians. I'm not sure about asking a country as poor as Cambodia to make that kind of sacrifice for the good of someone else. But, I mean, those are very personal feelings, but I think that there is a trade-off that needs to be looked at.
Right there.
You touched upon how occasionally there have been delays and failures, and I was wondering how often it occurs that maybe some of your larger, more powerful members, both groups, the voices sort of drown out smaller members that might have a better perspective, a better understanding of the culture or other issues going on that might have helped you get, prevent some of these delays, and what you guys do to try to combat that kind of activity.
I take it that's your question.
Yeah, I think that in part you're referring to the fact that the governance structure of the IMF uses a weighted voting power, unlike, for example, other international institutions, for example, the UN General Assembly, which has one country, one vote. In the IMF, one's vote is measured by the relative size of the economy in the world economy. So, for example, the United States voting power in the fund is close to 18%. So yes, there is we do have members that are larger than others. I think the effort is, however, when decisions are made in the fund, to do so to the extent possible by consensus. That's the first point. And that's not always possible, and especially in some of the more sensitive cases. The other point that I would make, however, and I think that this is one, if I may say so, I think that this is one of the unique characteristics of both the IMF and the World Bank, is that much of the work that Linn and I have been talking about in terms of capacity building is actually work that is organized and implemented by the staff of the institutions, rather than by the executive board, which operates the way you're talking. And in this respect, the IMF and the World Bank are different from other organizations like the WTO, where essentially you have a secretariat, but most of the policy work is done by the delegations. In the fund and the bank, you really do have a large, technically competent, we'd like to think, international civil service that is independent, that is doing a lot of this work. And I think that one of the reasons why both Linn and I feel strongly about the work we do is that we do believe it's independent, and we're trying to basically do what we think is right without taking into account political factors.
Well, I see that it's 12:15, so let me ask you to please join me in expressing appreciation for these wonderful panelists, Sean Hagan and Linn Hammergren.